Get over here, get over here. Yeah, the audience. Oh, yeah, I guess you could be right there. That'd be all right. That'd be okay if you sit over here.
Wait a minute, I gotta go with my knee brace and back brace. Hang on. It's in the truck.
All right.
Got hers, woman.
No, she forgot hers.
She got hers.
I said I need, man.
What I'm going to do is read the statement that I like to read in court for you because it's intended for you, really. You know, I really don't care about the court that much, just between you and I. Okay. My name is Bill Torres. I am the defendant, the appellant, and the petitioner in this case. The California courts have denied my unalienable rights to be judged by the community, and the community's equally unalienable right to do so in a trial by jury, and I demand that this right be upheld. I did not want to contend against the prosecution under the charge on December 14, 1990, because I was coerced into doing so by the prosecution's threat based upon a prior conviction of a mandatory prison sentence if I insisted on a jury trial. I have been in prison and I'm not intimidated by it. It's a wasteful and ineffective source of graduate criminals. What I wish to avoid at all costs is being separated from my two young children who have already suffered enough from this cruel and unusual persecution and who would miss me very much. The prosecution proposed to accept a no contest in exchange for not bringing up the prior conviction and their demand for a mandatory prison sentence. My attorney, David Ratman, made an impassioned plea suggesting that I plead nolo contendere and forfeit $4,500, which were taken as booty by the prosecution authorities to show good faith, and that the attorney would do his best to obtain probation, which he was confident would surely be granted, to keep me from being separated from my children. The attorney fees to present a medical or religious necessity defense were too high, $20,000 for a First Amendment defense, and my attorney persuaded me that pleading nolo contendere was the best way to prevent the separation and expressed confidence that probation would be granted. I was also confident that the no contest would mitigate the sentence and avoid the separation. No contest does not mean that one is guilty. It is merely a declaration of unwillingness to engage the prosecution. And in my case, I was unable to do so because I was broke and unable to present a common law defense of medical necessity. I also expected justice and mitigation from the court, as is implied by a declaration of no contest, in exchange for avoiding battle with the state. I was also discouraged by the attorney's fear of insisting upon such basic rights as a fully informed jury, and by his lack of faith on my views concerning the medicinal use of marijuana supported by physicians, and as a religious sacrament of the New Genesis congregation. I am literally sick to the stomach by the actions of the state, and the unity of my family and the safety of my children is in danger. I was also at the end of my financial ability to get competent counsel or to sustain any proper defense except on my own behalf. Therefore, I consented to the plea and to the court proceedings, with the understanding that the previous conviction and the mandatory prison sentence would not be invoked. A probation interview was scheduled, but in spite of his promise, my attorney failed to assist me in any way through the probation interview or application, and the attitude of the probation officers made it plain that the expected mitigation, which is intrinsic to the nolo contendere plea, was not to be. I also discovered at this time that the common law defense of medical necessity has been recognized by many courts throughout the United States including California. At least 34 state legislatures have recognized marijuana as medicine by overwhelming majorities. California passed Senate Bill 184 in 1979 by a 6-to-1 margin. I wish to withdraw the nolo contendere as soon as possible, but the defense attorney's mother was terminally ill with cancer, and he was not answering calls or keeping appointments. I attended probation interviews without benefit of counsel for the same reason. Evidence was presented to the Butte County Probation Department and the court concerning my long-time use of marijuana for medicinal purposes. Dr. Pendery, a physician, informed the court that if it was legal to do so, he would prescribe marijuana as medicine for my constellation of symptoms. There were also several letters submitted by friends and relatives who know of my use of marijuana and share my beliefs, asking the court for clemency because I'm not a criminal. I have been an occasional user of marijuana since 1949. I was drafted into the U.S. Army in 1951 and honorably discharged in 1956. I was an electronics instructor and engineer employed in research and development of weapon systems for the military-industrial complex for 22 years, from 1956 until 1978. By 1976, I had become an overweight alcoholic, suffering from glaucoma and chronic high blood pressure. Medical care and advice was of little help for my condition. My father died from the effects of alcohol at age 33. I discovered that regular smoking of marijuana stopped my chronic and frequent headaches and sharp eye pain. That it induced in me a peaceful, loving feeling, as you well know, and decreased my appetite for alcohol. When I returned to my physician, Dr. Vittoria Colas, as I had been doing on a regular basis, I was pleased to hear her say that for some reason my blood pressure was now normal, and she advised me to keep doing whatever you're doing now. That's what she said, keep doing whatever you're doing now. All prescriptions were allowed to lapse under the doctor's advice to prevent negative side effects which were not experienced with marijuana. A check showed my internal ocular pressure, the eyeball pressure, was lower, and my chronic headaches had miraculously disappeared. About this time I read Marijuana Medical Papers, a book which recounts a 5,000-year history of marijuana as medicine, and in which the editor, medical doctor Todd Mikuria, personally advocates marijuana substitution in the treatment of alcohol and narcotic addiction. I submitted a memorandum to inform the court and the probation department of the reasons I use marijuana and why I strongly believe that the prohibition of cannabis for medicine is contrary to reason and to our common law. Petitioner also submitted copies of The Emperor Wears No Clothes by Jack Herer and Marijuana Medical Papers by Dr. Todd Mikuria as offer of proof, and to inform them of the truth about a traditional use of cannabis sativa since the beginning of agriculture, medicine, and religion, without a single fatality attributed to it. Sentencing and probation hearings were reset to March 14th, April 5th, and finally to April 26, 1991. On April 26, 1991, having become aware of the right to present evidence to the jury concerning the common law defense of medical necessity, I advised the court that I wish to withdraw the no contest and demand a jury trial. The matter was reset to May 9th and then to May 23rd, when I filed a motion to withdraw plea of no contest. The matter was continued to May 30th. The court denied the motion to withdraw the no contest plea on May 30th, 1991, and sentenced me to state prison for the normal term of 2 years on June 7th, 1991. probation was denied because of the prior conviction, in violation of the nolo contendere agreement to not bring it up. I appealed to the 3rd District of the State Court of Appeal and filed a supplemental opening brief on November 2nd, 1981. The brief requests that the case be remanded to a trial by jury by the people of the state of California to allow me to present evidence to the people themselves relating to the common law defense of medical and religious necessity, because no issue of law is settled by a nolo contendere. No issue of fact is settled by a nolo contendere. The defendant has a right to present evidence to the people relating to the common law defense of medical necessity. The motion to suppress evidence should be upheld, and defendant's use of marijuana is protected by the free exercise clause of the First Amendment of the Bill of Rights. In my original case, the 2nd Appellate District described certain conditions under which the state has no compelling reason, no compelling interest in interfering with the people's right to freely exercise their own religion. In reversing the conviction of the Woody defendants, this is a peyote case, for violating former Health and Safety Code Section 11500, the California Supreme Court held that the state may abridge religious practices only upon a demonstration that some compelling interest outweighs the defendant's interest in religious freedom. First, the court then articulated a twofold analysis with respect to defense of religious freedom. They said, first, it must be determined whether the statute in question imposes any burden upon the free exercise of the defendant's religion. And second, if there is such a burden, whether some compelling state interest justifies the infringement. No such showing of compelling interest has been made by the state of California. The appellate court affirmed the case without a hearing on March 18, 1992, and denied the first petition for a writ of certiorari as a petition for rehearing. On April 24, 1992, I petitioned the California Supreme Court for a writ of certiorari or review to prevent a miscarriage of justice, to settle important questions of law, and to secure uniformity of decision. The grounds for review and certification to the Supreme Court being that the petitioner was denied equal protection under the laws declared in the Magna Carta, the First, Fifth, and Sixth Amendments of the Bill of Rights, and similar provisions of the State of California Declaration of Rights. The U.S. Constitution, Article 3, Section 3, declares that the trial of all crimes shall be by jury. The Fifth Amendment declares that no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. Nor shall any person be subject to the same offense to be twice put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. The Sixth Amendment demands a speedy and public trial in all criminal prosecutions by an impartial jury of the state and district where the crime was committed, to be informed of the nature and cause of the accusation, to be confronted with the witnesses against them, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. None of these charters say that the right of the accused to trial by jury can be waived. Good morning. How are you doing? Neither can the right of the people of the community to try him be waived by the accused not contesting the case. After all, it is your taxes which will be used to house the convict. So you should have a say-so in it. The right to trial by jury is a birthright which cannot be waived or given away or suspended by any one person or group under the common law and the Bill of Rights. The California Supreme Court denied the petition for review on June 10, 1992. Marijuana use has extended and probably saved my life. I have been healthy and regular since I started using it chronically, except for the recent occurrence of a stomach ulcer due to the stresses brought about by the present prosecution. In order to determine if I could keep a promise to stop using marijuana, I discontinued its use for an extended period of time. It was a mistake. I lost my appetite and found that there was a great deal of discomfort after I forced myself to eat. On one occasion, the pain was so sharp that I thought I was having a heart attack. I went to see Dr. Harry Pendry of Paradise. Based upon annual hospital x-rays, Dr. Pendry found that a bleeding ulcer has developed and prescribed Tagamet. Dr. Pendry also wrote a letter to the court expressing the opinion that marijuana would be most effective for my constellational symptoms and that he would prescribe it for me if it were legal to do so. I was pleased that the second physician, like Dr. Colas, also approved of my marijuana as medicine. Since then, I have read hundreds of affidavits from medical doctors and patients alike praising the virtues of marijuana as safe and effective medicine for many illnesses. I and thousands of others have been forced into an untenable situation by marijuana prohibition. I desire to obey all laws, but obedience to the statutory prohibitions is harmful to my health. And in the words of Drug Enforcement Administration Judge Francis L. Young, who said, marijuana has been accepted as capable of relieving the distress of great numbers of very ill people, and doing so with safety under medical supervision. It would be unreasonable, it would be arbitrary and capricious for the Drug Enforcement Administration to continue to stand between those sufferers and the benefits of the substance in light of the evidence in this record. In their 1988 annual report to the governor and legislature, the California Research Analysis Panel suggested that the legislature act to redirect the state away from the present destructive pathways of drug control. Our war on drugs for the past 50 years has been based on the principle of prohibition and has been manifestly unsuccessful in that we are now using more and a greater variety of drugs, legal and illegal. As with the novel experiment of the 18th Amendment, prohibition, as opposed to regulation, has not controlled drug use, and a societal overreaction has burdened us with ineffectual, inhumane, and expensive treatment, education, and enforcement efforts. The panel suggested to the governor and state legislature that whatever is being done in the area of drug abuse should be immediately modified. This is their own panel. The California Research Advisory Panel also suggested that legislation aiming at regulation and decriminalization should be formulated, including permitting the cultivation of marijuana for personal use. Yeah. Yeah. The California Medical Association's resolution of March 18, 1992 found that federal policy continues to be excessively restrictive, despite successive studies recommending to the contrary, including the 1944 New York Mayor's Committee, LaGuardia Report, the National Commission on Marijuana and Drug Abuse, 1973, the National Academy of Science and National Research Council, 1980, the decision of Judge Francis Young of the Drug Enforcement Administration in the lawsuit filed by the National Organization for the Reform of Marijuana Laws, and the executive summary of the 1988 California Research Advisory Panel report, which was censored by the Attorney General of California in 1990 because the panel advised policies of legalization of personal cultivation of marijuana. The California Medical Association also found that in response to this harmful policy that cause avoidable pain and morbidity, Proposition P was conceived to ask the citizens of the city and county of San Francisco to advise the California Medical Association and the state of California to restore cannabis to prescriptive availability to physicians. And the voters overwhelmingly approved the proposition by almost 4-1. 4 out of 5 voters said yes. I filed a petition for a writ of habeas corpus on August 11, 1992, which I have served on the Attorney General of California and the Butte County Superior Court as respondent. Petitioner has tried his best to make the court aware of all these facts, including the contempt for law which prohibition has created. My petition is that I cannot be, and I would not be, unreasonably commanded by the state to do what would be injurious to my health for mere arbitrary and capricious reasons. Signatures from over 300 citizens of Butte County were submitted to petition the court that Reverend William A. Torres, Brother Bill, be given a fair and impartial trial by a jury of his peers. To deny him the fundamental right of having the people themselves examine the facts and decide the issue is to treat him like a prisoner of war. It has become obvious during this proceeding that the courts and probation departments are not the best judges of fact concerning the people's right to use marijuana as medicine.
No, they're not.
They're not.
They're not.
They're not. They're not.
No.
Therefore, the petitioner insists that he is entitled to be tried by a fully informed jury of the people of Butte County.
Yeah.
Therefore, petitioner's imprisonment without benefit of trial by jury is offensive to our constitutions and constitutes cruel and unusual punishment in violation of the Bill of Rights. And I respectfully petition that the case be remanded to the people of Butte County, State of California, for due process of law, specifically a trial by jury, as required by all our basic charters. All right, so I guess we blew the 8:15 time.
Yeah,
By a jury trial? Because the people are entitled to try the accused, and the accused has a right to be tried by the people. We have to be tried by our neighbors rather than by some judicial unknowns. This judge doesn't know me from anybody, you know. I would rather make my case before the people who are here now.
I'm not totally clear on the charge. When I went in there, they said it was, what you told us, it was for medicinal use, but it's written down there as a selling.
Yes. If you have over a certain quantity of marijuana, they consider that you're selling it automatically.
Were you?
No.
It's strictly for medicinal use?
For medicinal use, and I smoke with my friends.
So why do you need it for medicinal use? What's the need?
The need, as I said before, in 1976, I had been working for the Defense Department for quite a length of time, and it's a lot of coffee, alcohol, and cigarettes that go along with this, you know. And I had become an alcoholic. I was hooked on the stuff. I would drink until I fell on the floor, you know what I mean? And I also had glaucoma, high blood pressure, and my doctor put me on some drugs that are hypotensive. But about this time, I started smoking marijuana more heavy through the influence of maybe my teenage children, you know what I mean?
And this worked?
And it worked. It worked fantastically well. My desire for alcohol decreased, and my blood pressure went down. I even stopped going to the doctor. I quit the drugs she was giving me. I had the ocular pressure tested by a doctor in Santa Maria, and it also went down. The figures I have heard is that it lowers your IOP or internal pressure in the eyeball by 30% or more. Yeah.
Thank you very much.
You're welcome.
Is she
brother.
going in there when?
Well, it's supposed to be at 8:15.
Yeah, they're not really on time, I guess.
They never are.
Yeah, I guess you were figuring that.
The people are ready, but they're not.
There's another question I had, but it's slipping my mind.
Or set a date, or
give me
or
a date.
honor the petition for a writ of habeas corpus.
Again, because this is the first I'm covering this. Up to this point, what has happened to you in court? You've been arraigned. And where did they catch you with this to begin with?
I've been fighting for my rights, brother.
A lot of his neighbors have even put forward their land bonds.
We believe in it
too.
What happened in those several years?
I have it all written down for you. As a matter of fact, here.
Yeah, I have a copy.
Yeah.
Do you have a synopsis?
Yeah, the last 2 pages.
You're here on, appearing in court today, what,
Yes.
probation violation?
No, not probation violation. It's, once you get one of these.
Yeah, I appreciate that.
Yeah.
Thank you.
And, Alan, do you have another one of these? Can you get one of these?
Hey! About half an hour ago.
It is that the media is allowed in there with a camera without having filed the form for that, for electronic media to be
I did file
allowed.
the form.
Yeah, well, why can't I?
I don't know.
Let's find out. I mean, how the hell, what do you do here? Is it because the media is controlled, that they know that you won't say anything that's too
It's because what we
subversive or anything?
show goes on the air and informs the public.
Informs the public?
Yeah.
Right.
They have 1,300 civil cases filed up.
They might never
probably be released by the time they get anything
1,300
done.
civil cases they have filed
I'm
up.
still waiting.
Yeah.
My appeal was granted by State Attorney General.
She didn't want to be quiet in there in the courthouse.
Yeah.
She wanted to say something there too.
Yeah.
So the bailiff said she'd have to leave.
The point is that I'm going to try and squeeze this rock right here called Butte County.
Right.
Don't want him.